Hello, class. I hope everyone is doing all right today. So, we have a test this week. That's fun. We have a test coming up on Wednesday or Thursday of your virtual day. Um, so, we're chapters 7 and 8. So, what we've gone over the last couple of weeks. I put together a study guide. I posted the guide in so you can just go at it at your own pace and kind of look over everything. Everything on the test will be somewhere in this guide, so you shouldn't get blindsided by anything. Of course, on the day of the test, we'll actually go and do a Kahoot just to review, um, and then you guys will go at it. But I think you guys should do all right on this. You guys have done all right on all the assignments so far, so I think we'll be good. But let's go over the study guide together, just so I can review it with you one last time. And then if you have any questions, email me, send me a remind message, get with me after before class, or ask the question during class, and we'll figure it out together, right? So in this test, we're going over a few things. So the first thing you guys need to know are just the normal contract terms, right? So valid means the contract is legally binding. Genuine assent is just basically the true and complete agreement. Voidable, if an injured party desires, they can just cancel the contract, void the contract. Rescission is when a party has a legal right to get back what they already put in. So if I gave you $20 in a contract and you wronged me, I could file for rescission, and you probably have to give me that $20 back. Ratification just confirms the intent to be bound by the contract. We went over grounds of avoidance. And this was just basically what are the grounds where a contract can be voided, right? So the first one we looked at was duress. So duress is a situation whereby a person performs as a result of violence, threat of violence, or other pressure. So the contract will obviously be voidable if it was entered into under duress. So when we look at contract and we look at duress, we look at four different things. So the first one is just the threat of illegal or tortious conduct, right? If you're going to commit a crime in order to pressure someone into a contract, it's not going to be a valid contract. It's just kind of common sense. So if you say, hey, sign this or I'm going to kill you, not going to work, right? Contract will be voided. This includes anyone, right? So if you threaten your family, so if there's an estate conflict where you and your brother are fighting over, a parent's will or whatever, and you threaten them, it's going to be the same if you threatened anyone else. Um, the next is threats to report crimes. So again, if you see a crime, you need to report it, right? So you can't hold a crime against someone. So say that I saw someone steal a car, then I'm entering a contract with this person. I don't know why you would enter a contract with someone you just saw steal a car, but if it arises, you can't say, "Hey, I saw you steal this car. I'm gonna turn you in if you don't sign this contract." Even though turning them in is the right thing to do, you can't hold it over them. The contract would not be valid. Same with threatening to sue someone, right? So if you are in a contract with someone over something else, you can't threaten to hold that contract and sue them on that contract if they don't enter into this new contract, right? So say I have someone doing the roof of my house, and then I'm hiring the same contractor to do something at my business. I can't say, "Hey, I'm going to sue you over the contract for my house. You didn't do a good job unless you sign this contract right here," right? That's not going to work. The new contract will not be valid. And then the last one is the economic threats, right? So it's when a party uses economic powers over another party. So think of it as a bigger company. You kind of have control over the smaller company. You say, hey, I'm not going to make this product for you unless you agree to pay 10% more than you are. That's not going to fly. The contract will be voided. The one exception is if a court can look for alternative is available, right? So if it's something where a company really can't afford to do it anymore, like say they are raising the price because that's how much their price raise, they're going to lose money if they don't, then the courts can kind of look for the party who is trying to sue or trying to get out of this contract and saying, hey, company C can do this for 10%. We'll let you out of this contract. You can enter a contract with company C for this price, right? And the next big one we looked at is undue influence. So, undue influence, if you remember, is when the dominating party basically has control of the dominated party. So, remember, it's when one person takes advantage of another person. So this will be voidable by the innocent party or the dominated party. The example I gave, and it's kind of a good one to remember undue influence by, is the 27-year-old unmarried female went to a priest for confession. He talked her into becoming a nun. She went for it, donated all of her possessions, including her stock options, to the church. She later was like, hey, I don't want to be a nun. I'm done with this. Got out, sued to get her stocks back, and the judge ruled in her favor, saying that she was subject to undue influence. A part of that is confidential relationship, right? So this is when one party has a large amount of trust placed in another party. So in her case, it was priest parishioner, right? She had a large amount of trust in the priest. Um, I don't want to say he took advantage of her in this situation because I don't think that was his intentions, but he has that influence over her. She's the dominated party, so she sued. Parent child, obviously, I can't take advantage of my kids to get them to do things they're little, but like if they were in college, I can't be that person where they have trust in me and me rip them off in some kind of contract situation. Attorney client is obviously another big one. The next thing we looked at are mistakes. So there's a couple of different types of mistakes. Unilateral is just when one party has the incorrect information. Generally, if this happens, the contract is still going to be valid, right? So if you didn't read the contract before signing it, if you don't understand what you're doing, the contract's still going to be valid. That fault is on yours. That's why it's important to get a good lawyer, right? So they can kind of go over all this information with you so you know what you're signing before you're signing it. The other mistake is a mutual, or also known as bilateral mistake. This is when both parties just have incorrect information. So it depends whether it's valid or void. Double depends on a few things. So if it's the identity of the subject matter, right? So if you both mistake over the actual subject you're doing the contract on, that's going to be voided because you're not really having that information. There's obviously something wrong. So, say you're selling a farm, you think it's 41 acres, but it's actually 27 acres. The contract's just going to be voided. Some things are going to be valid though. So, say the value of the actual subject. If you're both wrong, that's due diligence you should have done beforehand. The contract's still going to be valid. Same with the application of the law. If you're wrong about the law, it's still going to be valid. And again, this is why it's important for you guys to, or for anyone to get lawyers before you're entering into a big contract, just so they can go over this stuff, right? So you're going to spend maybe a couple grand in lawyer fees over a big contract, but that money is going to be well worth it compared to one of these mistakes or something like that. So lawyer up, right? It's a good lesson in life for everyone. Lawyer up. Misrepresentation is the other part. Misrepresentation is just a false statement or fact made by one party which induced the other party into a contract. So there's a few different types. There's innocent misrepresentation, when it happens when you just didn't know, right? So you're making a claim and you thought it was true, but it's really not, right? So that's just a mistake. It's innocent misrepresentation. You didn't mean to fool anyone? Yes and no. Fraudulent misrepresentation is aware and lied, right? So you know that you're lying. You are doing this to misrepresent your product. You're trying to get this person to buy this, and you're going to lie your butt off to get them to do it, right? Fraudulent misrepresentation. Regardless of it being innocent or fraudulent, the misrepresentations are voidable if the facts are misrepresented. So, misrepresented by the law is an untrue statement or act of concealment. The statement is material, or the victim relied on the statement. Right. So, the statement must be one of fact, not opinion. So, we kind of went over this in class, right? So, if you just give your opinion on something like the engine runs well, right? So what I say the engine runs well and what you think the engine runs well, it could be two different things, right? So that's just an opinion. If you do that, the contract's not going to be voided. Now, if you make a claim that isn't true, so say you say, yeah, this engine was rebuilt in 2018. Well, yeah, you're making a claim of fact, right? This was built in 2018. If it was not, that is a lie. That is a misrepresentation. That contract will be voided. The only thing that differs from this is if an expert makes an opinion, right? So if you have a car and you hire a mechanic and the mechanic says, yeah, this engine runs really well, that's an opinion of an expert, right? So that is going to sway the opinion different than if I were to say it, who I don't know anything about cars. Um, it's going to sway their opinion more, and that's going to be actually an example of a fraudulent misrepresentation, even though it was just an opinion statement by the mechanic. Get it? Get it? Good. All right. Concealment. So concealment is a false statement of fact. Um, so this is kind of like hiding something. So an example would be painting a ceiling to hide a stain due to a leaky roof, right? So you know it's leaking. You have someone coming over to look to buy your house. You paint over the leak. Say, yeah, nothing's wrong. You're concealing the truth. Silent concealment is just omitting material facts. So be something like, only drove the car once a week, but omitted that, you were racing the car on a drag strip or something, right? It's when a true statement becomes false. So the roof doesn't leak, but a few days later it does, right? So you have to kind of give that information out before signing into a contract. Or an incorrect basic assumption and the seller knows it. So I can see the foundation is solid, but you know that there's a flood every spring, right? So you know that it's bad, but it doesn't look bad, but you don't give that information, right? So you have to be upfront and honest with people, right? Honest. Materiality, which is a significant issue such as the subject matter, price, quantity, or type of work being done. So there's three ways to determine if it's material. A statement would cause a reasonable person to sign the contract. If the defendant knew the plaintiff would rely on the statement, or the defendant knew that the statement was false. You guys staying with me? So far, so good. All right. Then we look at reasonable reliance. So, reasonable reliance is where a victim must reasonably rely on the material information. So, again, it's the seller saying that they put tires on the new car when clearly they didn't. Um, and reasonable reliance can be fraud within misrepresentation, right? So, a statement was made recklessly or intentionally and it results in injury, right? So if you say you put new tires on a car, you didn't, the tire blows, the person wrecks, what do you think is going to happen? Right. So that's going to be misrepresentation. That's going to be fraud. So we look at some remedies for fraud. All right. So rescission, which is where the contract will just be voided by the injured party. everyone returns everything, right? So in that car scenario I just gave you, you bought a car. They said they had new tires. They didn't. Tire blew. You wrecked. You hurt yourself. You give the car back. They give you the money back. There's also damages, right? So if fraud is proven, you can seek damages for the loss created by the fraud. And then punitive damages, right? If fraud is proven, person's probably going to give you punished, right? Fine, jail time, something along those lines. So that is chapter 7. Now we go to chapter 8. So quick stretch break, right? Oh. All right. So consideration. So consideration is what a person demands and generally must receive in order to make his or her promise legally binding, right? So consideration can take form as money. It can take form as physical objects, services, promise actions, etc. So there's three different considerations or three elements of consideration: promised by each party, the exchange of something, and it must have value in the eyes of the law, right? So if I promise to give you a high five, you can't take me to court because a high five really doesn't have value in the eyes of the law. I mean, it should, right? Because my high fives are really cool, but it won't. So it has to have value. Some definitions to know is the promisor is the person making the promise. Promisee is the one who the promise is being made to. And again, for a promise to be valid, it needs to have consideration to make it legally binding. Another definition is forbearance. So this is agreeing not to exercise a legal right. Since it has legal value, your right has value. Forbearance is a consideration. We look at gifts, right? So transfer of ownership without receiving anything in return. So typically, a promise to gift is not enforceable. Remember, I showed you that really cool video in class um, where the guy promised that if his nephew didn't cuss or drink or smoke or gamble, I think those were the four, that he would give him, I don't remember, like $25,000, something like that. Um, and then the uncle died, right? So the guy didn't get anything in return because a promise to gift is not enforceable, right? Um, we look at donor. So after a donor, the person giving the gift intentionally transfers the gift to the donee, and the donee accepts it, the transaction becomes legally binding. So if you gift something, if you do actually gift it, right? So you give someone a $20,000 gift, they accept it, it's binding, right? You can't take that money back. No takes backsies. Is that what they call it? Is that what my kids call it? Take backsies? Yeah, none of that, right? So once you give it, it's theirs. If you promise to give it but you don't, you're in the clear, right? So legal value. So we kind of talked about things having legal value to make it enforceable. So what is legal value? So there's been a change in the party's legal position as a result of the contract. So most commonly, this is an exchange between two benefits, right? You get something, like something. So an example would be like, I watch your neighbor's house, or I watch my neighbor's house for the week. My neighbor gives me $100, right? So that is making legal value. A detriment. So remember, we talked about this in class too. So a detriment is a forbearance of a legal right. So in other words, a promise to refrain from doing something you have the legal right to do. So if your uncle pays you 10 grand not to drive until you're 25, you have the legal right to drive, right? Once you're 16, you go all out. But you're forgoing that right. You're to take the $10,000, so that's the detriment, right? You're not doing something you can in order to get something in return. When giving consideration, remember it does not need to be equal economic value, right? What you place a value on something might be totally different than what I place a value on, right? So values are can vary widely. So an example would be willing to pay more for ice water on a really hot day, right? It's hot outside. You're going to pay $2 for a cup of ice water because you're so thirsty and you need it. So if I'm selling the ice water on a cold day, am I going to make that much money? Probably not, right? Because you don't need it as bad. The same, I gave the example of the basketball card, right? So I was a huge New York Knicks fan back in the day. Patrick Ewing was my childhood hero. I don't know if you guys even know who Patrick Ewing is, but I would pay like major money for a Patrick Ewing rookie card versus someone in our class who probably has no clue who he is and want to take it for free. Maybe take it for free and try to sell it to me. I don't know, but it wouldn't have the same value to me as a would for you, right? When giving consideration, oh wait, just went over that. Should not be a misrepresentation, fraud, etc. So unconscionable means a gross unfairness or oppression. If consideration is received by one party that is so grossly inadequate, the contract will be declared unconscionable and voided. Right. So while contracts don't really go by economic value, they do have to kind of be fair, right? So it can't be just so one sided that it's like, no, well, this isn't gonna work. So there has to be, some kind of evenness. It can't be that unfair. And then lastly, nominal consideration. This is just a token amount identified in a written contract. Remember, some people don't want to post the value when they're advertising for something, or they simply don't know it, right? So they just put $1. So are they going to sell their dining room table or their used car or whatever for $1? No, but they don't know the value. They want to kind of spark negotiations, so they just represent it by $1. Next, we look at questionable considerations, and I am doing this without a drink of water. I am feeling good. Hope you guys are staying with me. Let's go ahead. You know what? Let's do a extra credit point for the test. Okay. So I will put on the last question of the test. I will put an extra credit point. I will just say, "What's the phrase or word I told you in the note video?" So let's do this. So I am a huge Harry Potter fan. On top of Dave Matthews and Jeeps and everything else, love Harry Potter. All right, absolutely love him. My family loves him. My daughter my oldest daughter had cancer. She was in fourth grade, so like 4 years ago. All right, and she got to make a wish trip, and we went to Harry Potter World, and it kind of changed my views on things. Harry Potter World at Universal, and it kind of changed my views and always been a special trip. So Harry Potter's always been like a special thing to me. Um, my daughter is fine now. She is in remission and doing great. She's a pain in the butt, but she is doing great. Um, so the extra credit that was too much information, right? I'm going through all this stuff, and I threw that out. So the extra credit point is going to be Slytherin. All right. So that is my favorite Harry Potter house. It's the bad guy house, but I think they have some good. And I like it when people think you're bad, but you're really nice and kind, right? So Slytherin. So that's Slytherin. All right. If you get close to it, or if you just say the snake house or whatever, I'll give you the extra credit point. But there you go. For 2 points on the test, Slytherin. Moving on. All right. Questionable consideration. Illusory promises, right? So that is a contract that contains a clause that allows you to escape the legal obligations. So basically, it's a termination cause. So if you need to get out of something, you have that. A normal one is like either party can cancel in 30 days with written notice. So a lot of that is in business or sometimes even a lease if you're just doing month to month. So give us 30 notice or 30 days notice in advance. You can get out of the contract. So right, that's an illusory promise. An output contract is when buyers agree to purchase all of a particular producer's production. Um, right. So courts or contract can be terminated if one party elects to stop the production. Courts recognize these contracts as supported by consideration. So courts recognize that no business should be required to go bankrupt by staying in an output contract. So they will void the contract if it becomes unprofitable through no fault of the terminating party. Right. So if you're agreed to produce or buy coal or something for your company from another company and you've realized that it's unprofitable to do that, you can typically get out of that contract. Existing duty. So, existing duty is another form of consideration, right? So, if you already have the duty to do something, you can't enter a contract to get paid more to do the thing that's your actual job, right? So, police officers, they can't collect more money for catching a criminal. I can't charge you for tutoring you um, if you're my student in my class, right? So for you guys, if you need help with business law, I can't be like, yeah, I can help you after class, but it's going to be like $30 an hour. Yeah, I can't do that, right? I'm your teacher, so I should just be helping you after class for free, right? Um, an existing private duty. If a contract creates a duty, this duty cannot be the basis for consideration for a different contract. So if I hire a person to repair my roof at my house, I need something done at my business, I can't hold that person to the same terms as I did when they were repairing my house, right? It's going to be a totally different contract. Liquidated debt. So parties agree that the debt exists in the amount of the debt, right? So this is when I know how much I owe. I know that I owe it. I agree. The creditor agrees. We're all on the same page, right? So the creditor is going to be the person who a debt is owed. The debtor would be the person who owes money. There is no consideration if the debt is liquidated, right? We just know the amount owes. Um, if the debtor settles a claim by paying less than the amount of the additional consideration would be given. So this must be a mutual agreement between the creditor and the debtor to do so. So an example would be a creditor receives early payoff on a high credit card balance. In return, the debtor would pay a lot less than the full amount, right? So the creditor is getting money early. They know that they're actually getting the money. The debtor is good with it because they're paying less than the full amount. Um, all parties are happy. Unliquidated debt is a little different, right? So this is where parties actually dispute on the amount owed. A term under unliquidated debt was accord and satisfaction. So, accord is the agreement, satisfaction is the actual act of payment. Um, so, the payment offered in a full settlement by the debtor and accepted by a creditor settles the claim, thus, accord and satisfaction. If a tort occurs, liability is unliquidated because the extent of the damage is uncertain, right? So the injured party can discharge the other party from liability in return for money. An example would be if you got in a car wreck, like a drunk driver hit you, all right, and you settled with them for $500,000 um, because you're paralyzed in the accident. So if you do that, then you can't take them back to court and get more money, right? composition with creditors. This is a group of creditors that will come together and accept less in return for debtor not filing bankruptcy. So when you look at like Freedom Debt Solutions, I think that's one, or National Debt Free. I could be making these names up. I don't know, but there's a ton of like debt companies out there that will consolidate your debt. Basically, do just this, right? They'll consolidate your debt. They'll work with the debtors to get them to accept less money than you owe, knowing that you're on the brink of bankruptcy, right? Um, so basically, it's better for them to get something than nothing. Then creditors will release the debt of the full payment. This kills your credit score, right? So the best thing to do is not get in this situation in the first place, though it is a better option than bankruptcy. Past consideration is an act that has already been performed, cannot serve as consideration for a later promise, right? So if I'm sick and my neighbor painted my house for me, and I promise to give him like, I don't know, $200 for painting my house, my payment can't be enforced since he already paid in the living room, right? And nothing was promised beforehand. So that's just me saying something, even though, it's not going to really be enforced. Mutual gifts is something of value that is given by one party to another without demanding anything in return. Right. So something of value is not consideration for anything later promised. So a person gifts you a car, you promise to pay them later, your promise can't be enforced since they already gave you a car, right? So mutual gifts is the same kind of as past consideration. If it's already done, then you don't really have to give anything back in return. So when is consideration not required in a contract, right? So promises to charities. So places like churches, hospitals, many nonprofits, some schools, they rely on donations, right? So people either donate money or make a pledge or a promise to pay in the future. So the person that makes the pledge receives nominal consideration. A lot of times they don't get anything in return. Sometimes, if you pay enough, you get a building named after you or something like that. Courts will generally enforce pledges for a specified use, right? So if the church is raising money for a new wing and you pledge to give them, a couple $1,000s to go towards that new wing, the courts will enforce that pledge. Same with like hospitals. If you offer to buy new machinery or pledge to give money to a new like MRI machine, um, they're going to enforce that pledge. The one exception would be the dead man status. So the dead man status is just cancellation of an oral pledge made to a charity by a deceased person closely before his or her death, right? So you're on your deathbed. It's when you are the most vulnerable, right? You want to try to give back all you can, and you say, I'm going to give all my belongings to the church. Right? Who's that going to upset a little bit? Probably going to upset your family, right? So if that's the case, then the courts aren't going to enforce that, right? Because what you say on your deathbed isn't probably given much thought to it, right? So they're not going to accept that. The other thing is promises covered by the UCC. All right, so a firm offer is when a merchant makes an offer in writing for a specific time period. Again, these offers could only be good for up to 3 months. No consideration needs to be made or given to make it enforceable. It's enforceable even when no payment or other consideration has been given to the promise. All right, so if you're a business or a merchant and you write something down, then it's going to be enforceable. Promise is barred by the collection of statutes. So the statutes of repose is the time a product was purchased within which a lawsuit can be due to injury. So if you buy something, and most of the time this is 12 years. So say you buy something that was over 12 years old, it was manufactured over 12 years old, you're not going to be able to bring a lawsuit because that was past the statutes of repose, right? If you bought something that was manufactured 10 years ago, depending on the state, maybe you can, right? Statute of limitations is for contracts and torts. So it cuts off the rights if not acted on by a certain deadline, right? So if something happened to you, most of the time it's 3 years, so 3 years ago or longer, you're not going to be able to go to court on those claims due to the statutes of limitations. Um, Another thing would be debts discharge and bankruptcy. So again, um, people can affirm different charges in bankruptcy. So when you file for bankruptcy, what happens is you put all of your debts together. So credit card debt, hospital bills. Problem is, you have other things too. So if you own a house, your house. If you own a car, your car. If you file for bankruptcy, do you want to lose your house and car? So you can affirm those. And the big thing is to when you have a cosigner, right? So if you guys are young, so say you get in college, you get into credit card issues, which some college students do, right? It's just part of life. Um, Chances are your parents are going to have to sign on if you buy a car or an apartment or whatever. Your parents are going to have to co-sign with you. So when you co-sign and file for bankruptcy, that's going to hit your parents' bank. That's going to hit your parents' credit report as a bankruptcy too on those items, which hurts their credit quite a bit. They will not be happy. So if you affirm those charges in bankruptcy, which means you say you're still going to pay for them, then they should be all right. We're on our last one. Sorry, I had to scroll down. Promissory estoppel. Last point. So, someone that makes a promise, you rely on the promise, you act on the promise, but the person doesn't come through. Courts create a contract for justice, right? So, for courts to invoke promissory estoppel, the promisor should reasonably foresee that the promisee will rely on the promise, right? That means if I am making you a promise and I know that you're going to use that information for the promise, then I did something wrong, right? The promisee does, in fact, rely on it. So not only do I know that you're going to rely on it, but then you actually do rely on it. And then you suffer economic loss due to that. Injustice can be avoided only by enforcement of the promise, right? So if you go through everything, I make a promise, that's a lie, I know you're going to use it, you act on the promise I gave you, you lose something, then promissory estoppel can be evoked. All right, so that is that. Again, I posted that online so you can just look at it and go at it on your own speed. Definitely study for that test. It's a big one, right? All these tests affect your grades. So if you have any questions, email me, remind me, send me a Canvas message, talk to me in class. We will hash it out, and then I will just see you guys tomorrow. Have a good day.